Hello all, today I'll be presenting the landmark case of Gideon versus Wainwright, 1963. In 1961, Mr. Clarence Earl Gideon was charged with breaking and entering with the intent to commit a misdemeanor, which in the state of Florida is a felony. At this time, Florida law only appointed counsel to poor defendants who were charged with capital offenses. So therefore, when Mr. Gideon asked for counsel, the appointed judge denied the request. During trial, Mr. Gideon defended himself the best he could. He presented an opening statement, cross-examined witnesses, presented his own witnesses, and even stressed his innocence. However, despite all his efforts, the jury still found him guilty, and he was sentenced to 5 years in prison. While in prison, Mr. Gideon filed a petition for writ of habeas corpus, claiming that his constitutional rights had been violated. The Supreme Court accepted the case, and on March 18, 1963, presented its ruling. Within its ruling, the court overruled Betts v. Brandy. The court held that the Sixth Amendment guarantee of counsel is a fundamental right necessary for a fair trial. The court stated that the assistance of counsel is one of the safeguards of the Sixth Amendment, being necessary to ensure fundamental human rights of life and liberty. They further stated that since the beginning, our state and national constitution and laws have laid great emphasis on procedural and substantive safeguards designed to assure fair trials before impartial tribunals in which every defendant stands equal before the law. This noble ideal could not be realized if the poor man charged with a crime has to face his accusers without a lawyer to assist him. Therefore, the court reversed the decisions of the lower courts and remanded this case for further review. Agreeing with the decisions of the court, 2 justices wrote concurring opinions. Justice Clark stated that the Constitution does not make any distinctions between capital and non-capital cases, but it did require procedural protections. So therefore, this protection should not be different between the 2 different cases. Justice Harlan stated that since all felony criminal trials involve special circumstances, states should be required to provide lawyers for all indigent defendants. After the ruling of the case, nearly 2,000 inmates that were convicted in the state of Florida were freed. However, Mr. Gideon himself was not. He was actually given a retrial on August 5, 1963. He personally selected Mr. W. Fred Turner to be his appointed attorney. Needless to say, he won the trial. As a result of the case, the rights set forth in the Constitution were enforced more strategically. Many changes were made to the public defender system. All state courts were required to offer the service of properly trained public defenders to all criminal cases. Even 4 years later, these same rights were extended to children. Since Gideon versus Wainwright, the government has supported the civil legal aid through federal funding, and in 1975, the first LSC board was established. When it comes to Gideon versus Wainwright, I do agree with the outcome of the case. How could we expect any defendants to have a fair trial against a legal system so prestigious as ours without counsel? As it was stated in the Constitution, as it was stated from the Supreme Court, the assistance of counsel is necessary to assure human life and liberty. If the case had been decided differently, the Supreme Court would still be facing these cases today. They would be continually having to take the case on a case-by-case basis, and also a lot more defendants would have been locked up only because they were too poor to afford their own counsel.